This webinar has been organised by the Alliance with support from RSM, and I am Fiona Bell, Chair of the Share Scheme Experts Group and a partner in RSM Legal. And joining me will be Andy Goodman of BDO, Elizabeth Grout of Travers Smith, Jennifer Rudman of Equinity. That's me, and it's important to run through some of the housekeeping points. And the main thing is the question and answer functionality. We want to run through our presentations, but we also want to deal with your questions at the end. So there's a box in the bottom right-hand corner, which is shown surrounded by a red border here. If you'd like to tap into that, you should be able to bring that up and type in your questions. So, moving forward, Andy will be looking at the main different types of plans to consider for smaller quoted companies. Elizabeth will be focusing on the legal considerations when establishing and operating share plans, and Jennifer will be looking at the administration features. I'm going to start off by looking at some stats and in particular the statistics produced by HMRC. And what I want to focus on there is the flat dash in the middle. You can see that this covers the period 2000 to 2018. And throughout that period, there's been a steady rise in most types of plans, particularly EMI plans. Although there was a flattening in the tough years of 2008 to 2012, but then it began to rise again. And I think the next slide tends to indicate why that is. Even through tough years, you still get some very good tax relief. Looking now at the Quoted Companies Alliance Employee Share Scheme Survey, where we surveyed members and we had responses from this year, 61 participants. EMI schemes, that's the Enterprise Management Incentive Schemes, remain popular at 44% of the plans. But you'll also see that company share option plans, which is the tax advantaged variety, that's becoming more popular. And apologies again if the screen is jumping in front of you. I'm not sure how that's happening. You will see that, yes, CSOPs have grown in popularity, whereas LTIPs, the non-tax advantaged variety, have declined. Share incentive plans seem to have dropped out of the top three. The main reasons for using employee share schemes remains to reward employees, and that's becoming even more popular, and perhaps may continue to grow in popularity in the next year or so. But the need to recruit and retain staff, but also to encourage employee ownership, remains important. You'll see that our members continue to use the QCA Corporate Governance Code to help them design their plans. But there are still issues relating to understanding the range of employee share schemes available, and also understanding the share performance and risk issues. So that's the reason why this hopefully is still a very useful talk and presentation. And I'm going to move over to Andy. I apologise for my glitches and hope that it all worked well with Andy.
Thanks, Fiona. Let's hope so. Fiona, you're still controlling the slides, I believe. So if you are able to move on to slide 9, please, with the key structures and the key drivers. So I'm going to talk this morning for a little bit about essentially how companies, smaller listed companies, will come up with the right structure and the right design of their plan. And I will also talk a little bit about the world we find ourselves in today, which obviously includes remote webinars, but more importantly, the impact of COVID-19. The diagram I've got here is not an exhaustive diagram, but it is essentially here to demonstrate the factors that might drive a company down a certain structure. Towards the middle of the diagram, my green blobs here have tried to capture very broadly the different types of scheme, and my orange circles around the outside are showing the factors that might drive a company to go down one route or the other. I'm not going to go fully around the circle and sort of try and address each one, obviously due to time constraints, but if we look, for example, at shareholder dilution, so for some companies, the market cap and the levels of grant that they want to make to people mean that shareholder dilution is not a particularly constraining factor. Whereas for other companies, it is hugely important that they are able to grant awards that are effective to incentivize and retain the right people, but that work within shareholder approved dilution limits. And if, for example, a company is finding that shareholder dilution is a key factor, that may push them away, for example, from market value share options and towards whole share awards generally being less dilutive than market value share options, or possibly even towards cash awards, which are obviously not dilutive at all, but they use the cash in the business. Other factors here, I've got corporate culture. So there may be a corporate culture that wants to see essentially investment by management alongside the shareholders. And so then you would have co-investment plans and reinvestment plans where potentially part of a bonus is seen to being reinvested in the share plan. And that's all to do with the sort of the culture that a company might want to drive. And we've also got on the outside here business strategy. So if a business strategy is focused heavily on share price growth, that may well push the business towards granting market value share options, whereas there are some smaller listed companies where they know that share price growth is sort of a longer term aspiration, and in the shorter term there are other factors and KPIs that management should be assessed upon. In that case, it may be that whole share awards are more appropriate. And there is a consistent thread through this presentation that refers back to tax. The tax treatment is another driver, and tax treatment may push us towards, for example, market value share options. So we'll talk a little bit more about approved plans. Fiona's already touched on EMI and CSOP, and the tax efficiency is more driven towards market value share options than some of these other types of award. So Fiona, if you would move on to the next slide, please. So these are questions around the design of the plan. So essentially the principle here is that any of those structures are driven by quite strategic factors, and then once we have decided as a company which is the most appropriate structure for our LTIP or our incentive plan, then there are questions around detailed design, and in theory these detailed design points could be applied to any of those structures. In practice, the two will very much interact, and so decisions around structure will interact with the decisions around design. But in theory, you come out with your structure and then you say, okay, so what are the detailed design points I need to think about within that structure? And so, for example, the vesting period, and the sort of investor sentiment here is for vesting periods and performance periods to have sort of ideally a sort of a 5-year timeline to them, where maybe there would be a 3-year period of performance and then maybe another 2 years where the awards don't actually vest, and so that there is seen to be a sort of a 5-year lock-in. Now that has to be set off against the goals of the company, the strategy of the company, and what is sort of appropriate for the participants. So there will be lots of listed companies who would say that actually our strategy isn't aligned with a 5-year performance period. Certainly smaller listed companies who may be envisaging that there would be some kind of corporate event within that time period. And therefore getting the right vesting period that is acceptable to investors, but also that works for the business and for the participants is key. And as I say, you would look to fit that really within any of the structures that I spoke about on the previous slide. Performance conditions I've spoken about. So investors would expect to see performance conditions, particularly for executives, senior management, but certainly there are smaller listed companies that I speak to who would say that they feel that driving share price growth through a market value share option is performance condition in itself. Now that needs to be agreed with shareholders, and investors don't look at things that way, but ultimately what is an appropriate performance condition, again squaring off the sort of the general expectations of the investor community as against what works for the participants and for the business, is an absolutely key design factor. Then we get into participation and quantum and what should be granted to people, which is obviously hugely important around making sure that the right people are incentivized in the right way, and that you kind of square off long-term, medium-term measures and make sure that everything is balanced. And then we get into factors that are probably seen as being a bit more vanilla, such as what happens for levers, what happens on a corporate transaction. And then my final bullet points on this slide talk about the accounting cost and the tax benefits. Accounting it comes back into the design, because if you have for example, a TSR, performance condition, total shareholder return, you're potentially going to get a different accounting treatment than if you have an earnings per share performance condition. So whilst we want to get the right condition from a commercial perspective, we do need to think about the accounting. And also we talk about tax benefits here. Any of those structures above can potentially be put into some form of tax efficient wrapper if that works for the business. And as I said, tax is a bit of a thread through this, through my slides. So I will come back to tax in a slide or two. So if we jump onto the next slide, please, Fiona. So here we are, tax efficiency. So I guess very quickly, tax efficiency with my clients can vary significantly. So there are some who would see a tax efficient outcome as being hugely important. There are others who would say that they don't want to spend any time thinking about tax efficiency. Tax efficiency for participants generally means that they get some form of capital gains tax treatment on the gains that they make, as opposed to pay as you earn national insurance. And I guess very briefly, the way that I would think about tax efficiency and whether or not you would go down that route, the approved plans or tax advantage plans that Fiona spoke about, EMI has been demonstrated as being increasingly important as the other schemes have kind of become less prevalent, and Fiona has also shown that the EMI is dominant even for the listed companies in the QCA. EMI and CSOP, they essentially are a win-win. So if you can use those plans and you can use them effectively, then there's kind of no real reason not to. Whereas once you get into some of the other plans that I've referred to here in the JSOP and using growth shares, that brings the potential tax efficiency, but it also leaves complexity, potentially some risk for the participants, and potentially a less tax efficient outcome for the company in terms of losing corporation tax relief. So once we go past tax advantage plans, then the other tax efficient wrappers are very much to be considered on a case-by-case basis to see whether they are really desirable for a company. So if we could go on to the next slide, please, Fiona. I will briefly just touch on all employee plans. So pretty much everything I've spoken about before so far has been kind of focused on executive plans and plans, discretionary plans. Obviously, how a company uses its sort of equity dilution for share plans is really important, and deciding whether that should go exclusively to executives and senior management, or whether actually there is a real benefit to equity being passed out on a broader basis. That will certainly vary company to company and sector to sector, but there's a very clear benefit in many companies in having wider employee ownership. I touch here on the SIP and the SAYE, so they are the two HMRC tax advantage plans that are driven towards all employee share ownership. And obviously they will often be run alongside executive plans rather than sort of instead of. So if we could go on to, I think, my final slide, please, Fiona, which is around COVID-19. So very briefly, just on things that people are thinking about in the current environment. So my top left blob talks about the operation of existing plans. So we find ourselves now where there are many plans that have got underwater options. They've got performance conditions that may have looked like they were going to be hit and may suddenly look like they are not going to be hit. Those are issues that have been seen in the past. They're very challenging for companies, and I think we're currently in the eye of the storm, and I very much doubt that companies, listed companies, are going to be jumping to do things to realign their option plans and their LTIPs whilst we're in such a sort of a crisis situation. They will be things that we will look at when we hopefully start to come out the other side. Needless to say, there is a real sensitivity around investors who will have taken a lot of pain, and the sort of the view that the management team, I guess, should share that pain. And if they've got options that are underwater, or if they've got performance conditions that look like they're not going to be met, well, that's the impact of an economic downturn, and not something that you would try to fix. And therefore, repricing options and changing performance criteria, for example, are things that you would do very warily. Clearly, a business needs to make sure that if it's got a high-performing management team, that management team continues to be incentivized and locked into the business. And so looking at sort of how you make awards going forward and how you respond to that is definitely something that companies need to look at, but they do need to tread very carefully. HMRC tax advantage plans. So probably the key concern relates to EMI, and there is a working time requirement under EMI where people need to be working either 25 hours a week or 75% of their working time. And so people who potentially have been put on furlough, they don't meet that requirement anymore. And by not meeting that requirement, that is potentially or likely to be a disqualifying event in relation to existing options. Now, I think everybody at the moment is waiting to see whether HMRC are going to try and find a way to give a concession around that. So that's a bit of a watch this space place, but certainly the furloughing of staff and people who are essentially not working at the moment but are still employees is a particular challenge in relation to EMI. And there are similar considerations in relation to all employee plans where people are not earning, so whether they're able to save into SAYE or make purchases under SIP are all things that need to be navigated. And so you should definitely essentially speak to your advisors if you have those plans and you've got people in that position. Online filing, so there are a number of reporting deadlines. So HMRC have extended the sort of period they're allowing EMI valuations to be extended for example, which has now generally gone to 120 days. But with online filing, that date of the 6th of July is still there, and so obviously no one knows what the future holds, but the expectation is that that date may not change, and therefore, despite the fact that people have got a lot of things to focus on, that filing deadline for the share plan reporting is still there. And finally, something around cash preservation. So we've seen lots in the papers around people reducing salary and so on, and how that interacts with share plans. Again, it needs to be looked at very carefully, and people don't want to be seen to be taking advantage of low share prices and so on. But it's another thing that people are thinking about at the moment. Okay, so that's a very quick jump through COVID-19. And that's me done. So I will now pass you over to Elizabeth.
Thank you very much, Andy. Fiona, if we could move on to slide 15. And as Fiona mentioned at the beginning of this webinar, I will be having a look at the legal considerations that companies need to take into account when establishing and operating their share plans. And as you will see on this slide, there are a number of topics, and to be fair, each of them could warrant a separate webinar in their own right. So the purpose of my talk today is to give you an overview of the legal topics that you and your advisors will obviously have to consider alongside the design of your plan. So when your plan is taking shape, you will also need to factor in these considerations. So moving on to the next slide, please, Fiona. We will be starting with the company law requirements that underpin the creation of a share plan and the opportunity and ability to offer a share plan to your employees. And one of the fundamental points that you will need to ensure in order to benefit from a number of different exemptions is that your plan is an employee share scheme, which sounds obvious, but this broadly means that if you have participants who are not employees, for example, consultants or other types of service providers to your business, and or if you wish for non-executive directors who don't also have an employment relationship with you to participate in your share plan, you will not be able to fall within this definition of employee share scheme, and you will need to take specialist advice. But assuming your plan is only available to employees of your group and the subsidiaries of your company and the subsidiaries in your group, why is this important? Well, under the Companies Act, the default position is that if you want to offer shares, issue shares in the context of an employee share scheme, you don't need to get shareholder approval first in order to allot those shares. Similarly, you do not need to get approval to disapply any preemption rights that the Companies Act gives to shareholders. And this is very beneficial. Having said all that, you may have something different in your articles. You may have a relationship agreement with a majority investor, which also says something different. So whilst the default position is that if you have an employee share scheme, you don't need to consider your authorities to allot on your disapplication of preemption rights, you should always consult the company's constitution as well as any relationship agreements you might have. One point to note in relation to an area where you may need approval and an employee share scheme exemption does not exist is in the context of making loans to directors. So if as part of your share plan design you have some funding provided to participants, if those participants are directors, you would need to get shareholder approval depending on the size of those loans. And that's something not to forget and not to assume because you have an employee share scheme, you're home and dry. And one of the other considerations under the Companies Act is whether you are providing financial assistance in the context of your share scheme. And as a public company, so a PLC, you will be prohibited from providing financial assistance unless it's for an employee share scheme and provided the company's net assets are not reduced, or if they are reduced, that you have sufficient distributable reserves for that reduction. And what do I mean by financial assistance? Well, you may have an employee benefit trust that you would like to fund to subscribe for shares or acquire shares in the market in order to deliver shares to your employees. That would constitute financial assistance. And as I've just mentioned, any funding to individual employees to purchase shares or to cover their exercise monies, that would also potentially be financial assistance. So that's something to think about. And the employee share scheme definition in the Companies Act also crops up in some other rules and regulations that need to be taken into account. And it's broadly the same definition in two areas. One is the area of financial promotion. So when you market your plan to your employees, you will obviously be writing to them, potentially doing presentations to them, because you want to sell the plan. You want people to buy into it so it has the retentive effect that you're looking for it to have. In general terms, you are usually restricted from making those types of communications and promotions to the general public. But if you are doing it in the context of an employee share scheme, you should be able to fall within a number of exemptions to make sure, which means that you can have those conversations with your employees and also offer those shares and those plans to your employees. Another reason why you want to make sure you fall within this concept of employee share scheme is so that you do not trigger any of the requirements to publish a prospectus, so that you don't cause your plan to be an offer to the public. You may have heard this in the context of what we call the prospectus rules or the prospectus regulations. And provided you are operating an employee share scheme for employees in your company and your subsidiaries, you should not have to prepare a prospectus. But again, this is something that your legal advisors would make sure is the case. And then in this last bullet point in my slide considers whether you have any reporting obligations. Now, what do I mean by this? Well, for example, gender pay gap reporting, which for this year, because of COVID-19, has been suspended, but would ordinarily be required to be done by the 5th of April. And if your organization has 250 or more employees, whether you're a public or private company, whether you're AIM or fully listed, you'd be required to make a gender pay gap report. And you shouldn't forget that any share plans or other variable remuneration that you offer to your employees needs to be taken into account in that report. Happily, if you are not a quoted company, so if you are trading your shares on AIM, not the official list, you are not currently required to prepare any CEO pay ratio reporting, nor are you required to prepare a remuneration policy which is put to shareholders for a vote. Those are requirements that do not apply to AIM companies at the moment. So moving on to my next slide, please, Fiona. Clearly, and you'll be familiar with the rules that govern your relationship with the regulator, the AIM rules, and in some cases, if you are looking to move up to the official list, or if you may be looking at the listing rules and seeing how they require companies to operate their share plans. And as a starting point, if you're a newly admitted company, you may have thought of the share plans prior to coming to market, but you should also have a think about any locking arrangements that you may have agreed with your nominated advisor or any majority investor, which could impact the way you design your plan or operate it in the early years of coming to market. And again, I'm sure you all know that if you are AIM and or listed company, you are required to adopt a shared dealing policy, which governs the way in which your directors and your management and your employees deal in any shares in the company. Now, if you do have a shared dealing policy, it is worth making sure that it interacts neatly with the way your share plan is designed to work as well. In terms of AIM Rule 26 and the requirement to adopt a corporate governance code, of course, we would encourage everyone to look at the QCA's corporate governance code as one that can be adopted, but there are others out there. But the key is that you must choose a code and you must publish which code you have chosen and then comply with it. In terms of any requirement of the AIM regulator to get shareholder approval to adopt a scheme, there is no such requirement. Unlike in the listing rules, where you have to have approval for employee share schemes and long-term incentive schemes, as well as discounted option arrangements, there is no requirement under the AIM rules for the same to take place. However, some companies may have come to market making the point that they will get their shareholders' approval, in which case you have to honour those commitments, or you may have had to agree that with a majority investor that you might have. And not to forget that under AIM Rule 19, whilst you don't have to do a full remuneration policy like listed companies do, you will be having to report both payments and benefits that you make to any directors, and that includes directors who cease to be directors in the year. And you'll have to include details of all the share plan awards, bonuses, incentive arrangements that you pay your directors. So when you're thinking about how you're designed and what you're going to offer and the levels of award, you need to know that these will be made public. And this leads us on neatly to corporate governance. And Fiona, if you could move on to my next slide, please. And corporate governance is obviously a very wide umbrella term. And it looks at the way the various participants in a company, so you have your shareholders, your board of directors, your employees, how they all interact together to shape the company and steer it towards the best performance it can achieve in its business. And in the context of share plans, corporate governance has exploded in the last few years and is extremely important. And all investors, big and large, use it in order to scrutinize the way a company operates its plans. And we have many different guidelines, but one of the principal guidelines that companies look to are the Investment Association guidelines and their principles of remuneration. And whilst AIM companies are not required to adhere to these guidelines, they are encouraged to comply with the spirit of them. So you would look at those and you know, adapt them to make them appropriate for the size and the type of business that you have. Listed companies face censure if they don't comply with the guidelines, and they can be red-topped or publicly criticized, but that is not something that is currently being done for AIM companies. Having said this, so as I said, you know, the features of the guidelines are a very good starting point when you're designing your plan. And they shouldn't really be dismissed. And if you are looking to move up to the official list in the future, they are crucial because it will make that transition much more simple. And what do we mean in corporate governance terms and share plans? Where do you need to look to? Well, the requirements of corporate governance will most likely affect the design of your performance conditions. The key there obviously being reward for performance, not failure. Corporate governance looks at the limits on dilutions that companies are encouraged to impose, both on the level of awards that an individual can achieve, as well as the overall dilution that a company is able to have in terms of operating the plan for all its employees. Leaver provisions are something that investors may become interested in because, again, you don't want to reward people for failure, so depending on the circumstances for their departure will depend on what they should achieve when they leave. Vesting periods and holding periods, because the idea of an incentive plan is long-term alignment with the interest of shareholders. Malus and clawback, should you have the ability to take things away from individuals if something comes up that you weren't aware of at the time of the award and the vesting of the award, but comes to light later, for example, an error in the accounting or a mismanagement that comes to light later at a later date. And timing of grant. And this is important, and we'll look at that in the context of share dealing as well. But the timing of grant, the best practice would be to grant your awards in relatively short windows following the announcement of your results, because that's considered to be a time when the market itself has all the information relating to your company, and therefore the share price is, I suppose, at its purest at that time. Fiona, if we could go to my next slide on share dealing. So share dealing, one of the points to remember, even though companies on AIM are not subject to many of the requirements for corporate governance and the listing rules, they are subject to the legal requirements of the market abuse regime. Therefore, under the market abuse regime, employees and individuals are prohibited from dealing in shares in an AIM-listed company. And companies are prohibited from granting awards or permitting the sale or exercise of awards if at a time when inside information exists. So this prohibition applies both to the company granting the awards or permitting the dealing, as well as the individuals themselves. So it needs to be looked at each time and in the capacity of each different scenario. So the board itself taking decisions, and then the individuals whose awards it is. In addition to that general prohibition that you can't deal when there's price-sensitive information, directors and those who are described as persons discharging managerial responsibilities, so typically your executive management committee or team, they are prohibited from dealing 30 days prior to the announcement of your final or interim results, or if you publish results at different times, then 30 days prior to those publications. And there are very limited exemptions to this prohibition, and in my experience and to my knowledge, they are very rarely relied upon. So typically, most companies, honour this 30-day blanket prohibition. And when you do do a dealing that is outside of these time periods and not in a situation where there's price-sensitive information, you have to notify, as a company, you have to notify the market, but the individual also has a personal obligation to notify the Financial Conduct Authority, the FCA. And both of these notification requirements must be done within 3 days of the dealing. And sometimes you may be concerned that there's a dealing being done by a director or a manager that you are not aware of, but nonetheless, they have 3 days to tell the FCA and you have 3 days to tell the market. So having appropriate processes in place to understand who and when people are dealing is obviously very important in order for you to comply with this requirement. And then finally, Fiona, if we could move to my last slide, which just covers a few topics of the employment law. Now, it's generally advisable to make your share plan sit outside the term of a participant's employment contract. And this is to ensure that if the employment relationship terminates or breaks down, the rules of the plan and not the individual's employment contract will govern what happens to the awards. And you will have thought very carefully about your leaver provisions in your plan, and you will want those to take precedence over the employment contract. However, this is easier said than done, because obviously in practice, in offers of employment, when you're looking to recruit employees, often refer to the participation in a share plan. And that makes sense because your share plans will be quite a large part of the incentive package that you're offering, and it's a very cost-effective way of recruiting individuals. So the key is to make sure that any offers that you make it very clear that the arrangements are discretionary and that you do not make contractual promises about the levels of award or continuing participation that you may want to change in the future. So that's one thing to remember there. In terms of general data protection, I think Jennifer may mention this briefly as well in her talk, but make sure that if you have a privacy notice that applies to your workforce, that you include your share plan and participation in your share plan within that policy. In terms of your leaver provisions that I just touched upon earlier, if you are going to have discretionary treatment, so if you want to reserve judgment as to how to treat a particular leaver at any particular time, then you need to be sure that those discretions are exercised very carefully. You have clear commercial reasons for the way you've exercised your discretion, and you're not frivolous or discriminatory in any way, because then you may end up in a bit of bother. If you have a standalone malice and clawback policy, which many companies do have and applies across the board to all benefits and payments that they may make to their staff, then don't forget to include your share plan, any new share plan within that policy. Otherwise, you can also create your own malice and clawback provisions within the plan rules and the plan documentation. And when it comes to malice and clawback, which is these scenarios where you can take things off your award holders at a later date, after vesting typically, but sometimes before, if there is some very poor behavior, so gross misconduct, or if there is very financial irregularities, these provisions work best if the individuals have signed up to them in some way, shape or form. That's not to say that they wouldn't work if you have granted awards unilaterally and you include the rules in the provisions in the rules themselves. But if you are able to have people sign up to them, then they are much more likely to be enforceable. And one point I'm sure your legal advisors who are looking to devise your plan for you will definitely include in the rules is an exclusion clause to try and limit the ability of a participant to bring a claim for any loss of options or awards that they may have in the event that they cease to be your employee. This limit is legally sound for contractual claims. However, it doesn't work for claims that are statutory in nature, for example, unfair dismissal or any discrimination claims. That is just the way it is, and those claims, statutory claims, can only ever be excluded in a particular way and settlement, and that's accepted by share plan practitioners, but nonetheless, having an exclusion clause is still better than not having one. And that's all I was going to say on the legal considerations, and I will pass the baton on to Jennifer Rudman.
Good morning. I'm Jennifer Rudman from Equinity. I've got a few slides where I'll be looking at the administration aspects of share plans. So Fiona, if I could have my first slide, please. This first slide is about stakeholder engagement. So if your company is considering launching share plans, there is likely to be someone who's going to be given the responsibility for managing the project and overseeing the ongoing management of those plans. So that person or team will need to obtain some buy-in from a number of your internal stakeholders, and there's a list of those on the slide. There'll also be a variety of external stakeholders, including your tax and legal advisors. And if using an external administrator, they will be able to manage arrangements with the relevant savings carrier, an onshore trustee that's needed for the share incentive plan. They'll also have dealing processes in place. Arrangements may also need to be put in place with offshore trustees as well. So just moving on to the next slide, please. When setting up a share plan, it's important to agree how the shares will be delivered at the end of the plan. And there's a number of different ways to deliver the shares, including using new issued shares or treasury shares, where there'll be a requirement to monitor the number of shares issued to track dilution. EBT shares, either through an existing or new trustee, where shares can be market purchased and held in an EBT. Next slide, please. So how the plan is administered, you'll need to have someone in the company with responsibility for the plan's running, and that person will need to be able to manage key events such as the launches, awards, maturities and vestings. The day-to-day administration of the plan can be managed either in-house or outsourced to a specialist share plan administrator, or can be a combination of both. Typically, tax-advantaged all-employee share plans, so plans such as SAY and SIP, are usually outsourced with their processes linked to savings carrier, or through where they're managed in-house. You'll need to look at where there are post-vesting holding periods, and if so, how they will be managed. The numbers of participants will be a factor, as well as comparing the costs of in-house administration, and they'll be compared with the fees by using a third-party administrator. So the next slide, please. When launching a share plan, it's important to set out the timetable for events. This should take into account the overall corporate timetable. So if REMCO approval and shareholder approval is actually needed, then the AGM and REMCO meetings will be key. Some scheme rules set out that the plan can be launched, for example, when with SAY, it's usual to launch within about 42 days of the company's announcement of results. There'll also be periods when plans can't be launched, for example, if there are closed periods. Where external trustees and administrators are being appointed, timeframes for their appointments should be included in that timetable. Administrators will have template timetables that can be used for the actual launches. Eligibility data may be required, as well as payroll processes for deducting any contributions, and for calculating the tax and NIC and doing the processing of those. So again, checking timescales with HR and payroll will be required to ensure that they can support the additional work, both in terms of resource and the ability of the payroll systems to process contributions, deductions and tax. And the next slide, please. The next slide, this slide picks out some of the teams needed to support the launch, as well as the COSEC and HR support. appointing share plan champions at different business locations can be quite effective in promoting an all-employee share plan. Telephone and email helplines may be required as well. And on to the next slide, please. Communication strategies. If you're launching valuable employee share plans, it's definitely worth investing some time in deciding how you want to communicate that plan to eligible employees. There'll be some documents that are needed depending on the type of plan. However, other communication materials such as launch emails, brochures, posters, banners, table talkers, videos can also be used to bring some kind of colour and excitement to the launch. Other things to consider are, do all emails have access to emails? Should the communications be issued in paper or digital form? Will employee portals and web microsites be set up? Are there employees overseas, and will documents need translating? And the next slide, please, Fiona. Back to the day-to-day administration of the plan, keeping up-to-date records of employee participation data is important. So this slide just looks very quickly at some of the different parts of that process and some of the things that need to be built into administration processes. So on to the next slide, please. Again, there's information here about some share plan events, and it's helpful to maintain an annual calendar of share plan events. So if you have different types of plans, it's likely that in addition to day-to-day work, you'll be planning for some of these key events that are listed here. Next slide, please. With both all employee and discretionary plans, registration of the plan is likely to be required with HMRC along with annual reporting. So the online filing of annual tax returns is very important, with support material by your advisors and administrators on how to complete these. Other key reports include IFRS 2 reporting, maintaining headroom calculations, showing shares issued and potential requirements for share issuance in the future. Share plan benefits need to be included in your gender pay gap reporting, as already covered by Elizabeth. Next slide, please. A couple of regulatory requirements. One is around MiFID II reporting. And again, the data will either be collected at vesting or maturity for these, and will include information such as the national identifier, which in the UK is the national insurance number. And again, in relation to GDPR, where data is sent to a third-party administrators, you'll need to check the legal basis upon transferring the data, and this could form part of the employment contract or under the category of legitimate interest. The documentation should provide information about the various data controllers and links to the relevant privacy notices. There can be a variety of data controllers at different stages of the plan, and can include the company, the savings carrier for SAY, and the trustee for SIP, as well as the broker when it comes to dealing. And on to my final slide. At the end of the share plan, many employees will continue to hold shares and become a shareholder, so providing some information about what it means to be a shareholder should be included in your plan maturity documents. And just as a final point, there should be an assessment of the success of the share plan to validate whether or not the aims of the plan are being met, and this can include employee surveys. So that was a whistle-stop tour of my slides, so I'll hand back to Fiona.
Hello all. No, thank you very much. There are some really good points that have been mentioned by our speakers. We have some questions that have come in, and I wonder if I can just pose this first one perhaps to Andy to start off with. We have a question from Emma Blaney, who says, if an employee works 3 days a week and runs their own business for the other 2 days, does this mean they cannot have EMI options?
Broadly, the question there will be, that so the working time requirement, which essentially looks at, it starts off at grant looking at what someone's committed time is, which is essentially what they are committed to doing, and then the disqualifying events rules then look at not only what the committed time is, but also what the actual time is spent working. So if you are talking about this sort of 3/5 sum, then that doesn't meet the 75% requirement. So then the second question would be whether those 3 days constitute 25 hours a week, which in practice they may or may not do. But you would probably, if you wanted to get comfortable that the individual could receive EM options, you would probably want to formalise that those 3 days a week do constitute 25 hours in order for them to meet this kind of the second part of the test. And it's an either-or test. It's a 75% or 25 hours a week test. But if the question was partly looking at whether the sort of self-employed nature changed things, it doesn't. So self-employed is captured in the same way that employed is.
Thank you, Andy. I've got a question that perhaps I'd like to raise with Elizabeth. Of course, it's often said that it's good practice to have shareholder approval to plans, but it's not absolutely necessary for an EMI company, for an AIM-listed company. Elizabeth, at the moment, obviously, it's very difficult to just sort of set up and run a company general meeting. What's your thoughts about whether the position, if you have if you feel that you normally would have shareholder approval at this stage?
I think obviously you need to look at the legal position, the strict legal position, and if there is no requirement, for example, if you've recently come to market and in your admission document where you summarised a plan and you made a very strong commitment that when it's adopted it will be subject to shareholder approval, and going forward your plans will be subject to shareholder approval, then whilst you might not be bound by that commitment, you may have to put out an explanation as to why you've not been able to go to shareholders as a result of the circumstances. But there is no real legal requirement to get shareholder approval. So even if you have said you will, that's just a commitment to your shareholders. And if you can't get formal approval, but you still want to keep your shareholders engaged, you can obviously reach out to them in other ways, and you would reach out to the bigger players, I suppose, and consult with them on an informal basis to make sure that when the time comes and it is they are able to kind of meet in an AGM forum, they won't criticise you for having adopted the plan without shareholder approval. So unless there's something specifically requiring shareholder approval, either in your articles or in any relationship agreement you might have with a shareholder, there is no legal requirement to get approval, and so you would be able to explain, because of the circumstances, the reasons why you've not gone to do so. Now, if your plan is slightly left field and a little bit out there and deviates quite considerably from what we know investors consider to be best practice, then you would proceed with slight more caution. But if it's a normalish plan, then you're probably going to be okay. And in any event, there is no pushback. There's no legal pushback from the investors.
Thank you, Elizabeth. We've got another question that has come in. And I think this is looking at underwater options and the issues with share price at the moment. It's from Julian Pancholi, and it says, do presenters have a view on the use of out of money, at the money, or in the money RSUs and options? Are market perspectives changing around either type? Perhaps if I go first to Andy on that one.
Well, I guess I think my starting point would be I don't necessarily expect views to change. So I can't imagine that, for example, the Investment Association will change their views on things, notwithstanding the situation that we're in. I guess then there is a question around, so RSUs, as a general view, are not frowned upon, and they're fairly well used. I mean, they're obviously sort of something that's come primarily from use in the US, and they're very prevalent in the US, but more and more so in the UK. There is a sort of a strange scenario with RSUs where they're not generally seen as being granted at market value. So RSUs are generally seen as being something where you have a low or minimal amount payable for. But actually, in terms of their acceptability, it's much better that the individuals receive RSUs and don't pay anything for them, rather than being seen as an equivalent to a discounted share option, which is something that is generally seen by investors as being not acceptable. So it's a strange scenario where with RSUs you do want to go the whole hog and allow people to get them for free on vesting, and the sort of the justification around RSUs being acceptable in that circumstance is that they should have performance conditions on them, and awards probably there should be fewer shares that an executive would receive than if they were receiving a market value share option and they had to pay an exercise price.
Thank you, Andy. Jennifer, have you seen, I don't know whether you've seen any changes yet to the use of maybe reduced value or using out of the money or at the money. Have you seen any sort of practical changes come through yet?
Not so much now. The changes that are really being discussed at the moment is around using free shares or some type of award of shares instead of bonuses at the moment. So it's all around the cash preservation idea, and maybe using shares in other ways in order to satisfy bonuses or reward employees. So that's the kind of key topical thing that's being discussed at the moment that we're seeing.
Thank you, Jennifer. Elizabeth, do you see any sort of practical legal issues that arise granting options sort of or RSUs? Are there any particular legal issues that you see?
I think not so much. I mean, the legal issues are the same as discussed, but I think one thing that we're quite cautious on, and how when we're advising our clients, is that there needs to be care not to be there shouldn't be a perception that awards are being granted at this time to take advantage of the low share prices, and there needs to be consideration as to whether you need to build in a mechanism that will then cap the return potentially in years to come if it is considered to be excessive and not a product of the performance, but rather a product of the fact that the market is currently depressed and will then hopefully pick up. So I think a lot of our clients are concerned of the way that's going to look in the future. But otherwise, all types of plan can be considered, and I agree that if cash is if we're currently in a cash poor situation, using shares to keep people, incentivized in the business to potentially, work quite very hard to come out of this situation is a valid route. But just be aware of what it could look like in the future.
Thank you, Elizabeth. Jennifer, can I raise a point with you that I've been wondering about? And in the current situation, I mean, obviously, it's really, really important to communicate plans, not only at the start, but on a regular basis. And I wondered if, obviously, the current lockdown means that face-to-face presentations aren't really happening. And I just wondered if you were seeing any sort of clever devices or how companies were trying to deal with this at the moment.
Well, I think the key thing at the moment is that, especially if there's people on furlough and they're not picking up their work emails, we're seeing many more paper mailings being booked in and using the traditional paper postage instead of doing completely online email broadcasts and webinars, because a number of the employees obviously are at home now and they won't be picking up their usual way of communicating with the company. So I think that's the biggest thing, and then it's being able to schedule in those mailings with the mailing houses, with the people who furlough themselves. So that's the biggest change that we're seeing at the moment, just moving over towards paper mailings and just really checking employees, especially if they're based across the world, what is the best way of being able to communicate with them. And again, it's back to if you're trying to send some paper mailings overseas, then that might be restricted as well. So then it's just building in some time frames for overseas coordinators to be able to print off and mail those documents as well. So that's the main thing at the moment, getting the information out to employees that might not necessarily be picking up their normal email correspondence.
That's very interesting, Jennifer. Thank you for that. I can't see that we've got any further questions that have come in from the audience, but hopefully you'll have details of the various presenters and if you do have any questions and you'd like to contact us directly, we'll be very happy to see what we can do to answer your questions. I should also let you know that these slides will be made available, and I'd like to very much thank the presenters, Elizabeth, Andy and Jennifer, and also the people behind the scenes who have helped to put this on, including Danielle and Sam at the QCA. So thank you very, very much, and we look forward to seeing you face to face at our presentation.
Thank you, Fiona.
Thank you, Fiona.
Thanks.